Number 151, Pullman versus Silverman.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff appellant. If I can, I'd like to reserve 3 minutes for rebuttal argument.
How many minutes?
3 minutes for
Three.
rebuttal, please.
You have 3.
Your Honors, in my past experiences here, generally I've been asked a question, because you're the Court of Appeals, what should the law be? And when I was a far younger lawyer, approaching 60 now, unfortunately, but whatever, I didn't really have great answers for it. But now what I try to do is I try to give you exactly what the law should be and not generic. So here's what I want you to hold. I want this Court to adopt expressly Judge Sachs's concurring opinion in Marsh v. Smythe, which says, and I quote, it's quoted on page 16 of my brief, "It is not necessary that the underlying support for the theory consists of cases or studies considering circumstances exactly parallel to those under consideration in the litigation. It is sufficient if a synthesis of various studies or cases reasonably permits the conclusion reached by the expert." As far as my research...
What's a synthesis of studies here?
The synthesis of studies here is the mechanical studies dealing with what happens when somebody who is exceptionally heart fit. David Pullman has ridiculously great neurologic scores, has a precipitous drop in cholesterol. I'm not attacking, Judge Rivera, and I just want to be clear, I'm not attacking statins, okay? They work great for people who have heart disease. The problem here is that David Pullman never, and I mean never...
Where are the studies that connect taking this particular drug to the heart ailment he suffered?
Yes.
Where are those studies?
The studies are, there are 3 studies specifically dealing with athletes, and I can give you the pages of it. The first one is the Barold and Pedaletti study. It's on 1265 to 1269 of the record, specifically 1265. A study in which the authors were, and I'm quoting now, this is not my words, this is the author's words, quote, "unable to find, quote, a single case of precisely documented type 2 block in young athletes, finding that theory, this is their conclusion, was, quote, counterintuitive because it would imply serious disease where none exists." Second study, the Zahender study, 1798 to 1811, specifically 1800 to 1801. This is, again, a quote. Now, Brian Isaac, this is the study. 12,000 athletes. Here's the quote. "AV conduction normalized in all of these individuals with physical exercise and after discontinuation of high-performance sports during a 9-year observation period." Third study is the Tomaselli study on bradycardia in the Harrison textbook on medicine, which of course is the gold standard, in which they say, and this is on...
What's the site for that, Mr.
It's 1842 to 1856, and the page is 1844 to 1845. I know it's an unwieldy record, so I'm trying to give you the pages, where they say that heart block has 2 and only 2 causes. 1 is organic lesion, and 2 is an actual ingestion of a drug. David Pullman never...
Does it refer to the drug specifically at issue here?
It does not, for the simple
Do
reason...
any of these refer to this particular drug?
They don't refer
Or
this particular...
this category of drug?
They don't, and I will never, Judge Rivera, ever have a study that deals with it, because there is no medical reason on God's green earth to give Lipitor to somebody who doesn't have heart disease.
Okay, assuming you don't need a specific study showing that in that way, what you've done is you've drawn a number of links, okay? And you would agree that we said in Cornell that there are some gaps that are just too big to cross. And the question in my mind is that the case here? Because, you know, I agree with you that we don't need a specific study on every single issue. I don't think that's what Fried calls for. I don't think that's what our case law calls for. But at some point, it has to go beyond speculation is not quite the right word, but it has to really be based on something. And to me, there's a lot of leaps here, and I'm not sure that we cross those gaps.
Let me try to assuage your concerns if I can, Judge Stein. I agree with you that Cornell did talk about that. Cornell was a little different because in Cornell, there were three, on the AAIA report that was considered, there were three methodologies by which the mold could cause the damage, none of which the plaintiff had.
Well,
We did-
here you talk about rhabdomyolysis, or I'm not sure I'm saying that right, but there's no question here that the plaintiff didn't have that, right?
Well,
So, I mean, so
that's actually not correct, but
Okay.
let me answer that in two
Sorry.
parts, okay? What we did was we gave you a physiological basis for what happened to him. This is a guy who's in immaculate health. I mean, he's got a 110/70 blood pressure, 60 resting heart rate, 75/80 ejection heart rate fraction, 0 calcium score. You can't do better than that. 156 on his cholesterol. He's under no medication, and he's a 45-year-old man running 68-second repeat quarter intervals. Anybody who
Why
knows...
is he going to the doctor so much if he's in such great health? Isn't he basically going to the doctor every week, virtually?
Judge, there
I mean,
are-
that's a slight exaggeration.
I don't think he's going that much, but some people go to the doctor a fair amount. I should probably go a little more. Some people should probably go a little less. But the objective facts are the objective facts. So we gave you a roadmap for what happened. Here's what happens. High statins, Lipitor's work, they reduce the statins, you're okay. If you have low cholesterol and you have a precipitous reduction of the statins, Q10 enzyme, which is in 40 or 50 of the articles, which I apologize, I know you took a look at them and they're very, very hard to read, reduces. That in turn reduces adenosine triphosphate, ATP. ATP is the building block by which the heart actually functions. Heart block is a misnomer, obviously. There's no blockage at all. It's just an insufficiency of energy. And ATP is responsible, under our experts' analysis, for 85 to 90% of the heart's generation of energy. So we've given you an alternative that actually works here.
Let me ask you this. I read the science on it, but what I'm wondering about is,
They met their burden, and I think that if they did meet their burden, we certainly met our burden. Here's why I say they didn't.
so no, I don't want to leave this yet. I want to stay with this. So you're proceeding under a summary judgment standard, not a Fry standard, because I think a distinction needs to be drawn here, and there's some lack of clarity on that issue. So which is it?
Well, I think that they moved for summary judgment. I don't think it's a Friday
So
issue.
it's a summary judgment.
summary-
So
I think it's a
judgment
summary judgment
So
issue.
under summary judgment standard, then the defendant would have to come in and say, not that you don't have scientific studies, but they have scientific studies.
that links David Pullman's condition to the ingestion of Lipitor, no doubt because nobody else would have Lipitor in this situation. And he didn't give an answer as to what happened. He used the word idiopathic. Idiopathic just means I don't know. So if, Judge Fahey, we say this is a summary judgment motion,
I believe that's actually incorrect. Certainly absent the presence of rhabdomyolysis, and I may have pronounced it, mispronounced it also.
That's more of a factual question as to whether this
Okay.
was, but let's put that aside for now also. But to go back to, I think, what Judge Fahey and Judge Piggott are saying, when you come forward with your summary judgment motion, the plaintiff's claim, at least in part, is it was the combination of Lipitor and erythromycin. And doesn't it seem that your expert really opines as to Lipitor causing AV heart block, and then it's more conclusory statements as to the combined effect, one, and two, doesn't that also go to their point that why would you ever conduct a study of giving these people Lipitor and erythromycin if it's contraindicated?
Okay, first of all, I don't really think ours were that conclusory, but more importantly, this isn't really in dispute. If you look at two of their expert affidavits, they admit forthrightly that there's no studies linking this combination of drugs to AV blockage.
But if it's, and I think Judge Piggott mentioned, it may even be on a warning saying, don't combine these two drugs, right?
Again,
On a
I
Rite
factually-
Aid label, right? So why would you do a study combining the two drugs?
But again, these drugs are given to millions of people in worse condition, supposedly, than Mr. Pullman was, okay?
But are
It's
they
had-
given,
it's-
Counselor,
there's-
are they given to people in worse condition in combination in the way that plaintiff is claiming they were given to him?
I'm not sure I understand.
With
your
the
question.
Are they given
Azithromycin.
in combination? Are the two drugs given in combination to people in worse condition than the plaintiff?
There's
You're
been
saying
no-
Lipitor is something that 25 million people take a day. What
Yes,
about
I obviously do not, I
combination?
do not have a statistic about how many people take it as a combination.
Thank you, counsel.
Thank you.
Mr. Isaac?
Thank you, Your Honor. Judge Fahey, I didn't give you a great answer to your question before. I think I have a little bit of a better answer now. If you look on page 26, it's a straight summary judgment motion. He's not asking for a Fry hearing. He's moving for summary judgment under 3212. So he gets to set the table under, Alvarez, Zuckerman, it doesn't matter. Again, my adversary just made my point. 25 million, 50 million, 100 million people taking Lipitor, you take it if you have heart disease. That's the problem. David Pullman doesn't have heart disease, and guess who said so? Not Brian Isaac, not my adversary, David Silverman. I'm going to read you his quote with all of the adjectives in it as well. It's on page 540 of the record. He's asked, what was the plaintiff's condition when you prescribed Lipitor? And he said plaintiff had, quote, a 156 cholesterol scan, comma, optimal, his adjective, not mine, LDL and HDL levels, comma, fantastic, his adjective, not mine, triglycerides, comma, low, his adjective, not mine, level 60 pulse, 110 BP, and, quote, great, his adjective, not mine, exercise fraction differential 35 CRP where 190 is normal. That's the point.
But aren't we back to, regardless of whether or not that was the correct determination by the doctor to prescribe this particular drug, isn't the question whether or not the drug caused the injury?
You are, but the problem is that he's divorcing the nature of the malpractice from my inability to have a study. I agree that they're completely separate issues. Stukas against Steyer is a Second Department case. It's my case, where the Second Department said clearly you can split them up. But he can't tell me that I don't have a study that matches this if no doctor, no institution, no medical professional would do the study. Why would anyone?
No, I understand that. I guess perhaps I'm, again, not fully appreciating the arguments and perhaps not fully understanding what the record represents. But I thought the argument was that there are some studies. It's not that there are no studies. There may not be studies specific to what you're arguing about, but that the studies connect this drug to a particular reaction.
Yes.
Muscular reaction.
Judge Rivera.
And then your experts, let me just finish
Yes.
it off. Go then to the next step. That the muscle that's affected could very well be the heart, and that could be the situation in this case.
Yes.
And that the defendant's position is, first of all, those studies don't work, but again, correct me if I'm wrong, but that no one would use the studies to conclude this next step, to fill the gap in the way that I think Judge Stein was referring to before. And then we get back to whether or not it's summary judgment, Fry, Parker, something else. Am I misunderstanding?
You are not. Judge Rivera,
Where we have to zoom in?
Yes, you are 100% right. I was a little too emotional. I'm just responding to his argument, that's all.
As long as
there
you're the
are-
one emotional, not me. Go ahead.
There are studies, we think the synthesis of studies, including the temporal relationship, the proximate relevance, the fact that night sweats, inability to sleep, nightmares, all stuff that doesn't have a recognized side effects, that there's more than enough here. And just 2 more seconds. One judge, I forgot who, because it's a little hard when you're getting a lot of questions, asked whether or not rhabdomyolysis would actually be something that would have to be present. We showed that it wasn't. I just have the study. It's on page 321 of the record, and our experts said that you can have myopathy without having any clinical evidence of rhabdo because he discontinued the drug. That's at 346. Thank you for listening.
Thank you, counsel.